Morning, everyone. This meeting is called to order. Did Siri just interrupt me?
Yes.
No. Good morning, everyone. The meeting is called to order. Mr. Troman, has anyone signed up for public comment? Thank you. Good morning, Ms. Miller.
Good morning, sir.
We have no cases to reconsider under agenda item 3. Is that correct?
Correct, no cases.
Thank you.
All right, let's consider tax liability cases under agenda item 4, but I don't think we have any tax liability cases on docket 25.
Thank you.
Correct, no cases.
Fair housing cases on agenda item 5?
None, sir.
None. How about wage claim cases?
We have one pulled, sir.
Let's do that.
The case is case number 20-054656-3. Commissioner Alvarez.
The decision is not supportable. The claimant received the hearing notice for the first hearing after it occurred. The claimant is homeless. He attempted to he attempted to check the status of his appeal online, but there was no record of it. The claimant attempted to contact special hearings and was unable to get assistance on the status of his appeal. The claimant's latest receipt of the notice and his attempts to obtain the status of his claim established that he had good cause for missing the first hearing, good cause for a claimant's non-appearance, and resubmit.
Claimant missed the first hearing, and the employer's testimony and other evidence supports the AC's conclusion that the claimant was fully paid and was not entitled to any support. Claimant filed a request to reopen the hearing under Commission Rule 15, but testimony regarding why he did not call into the first hearing did not meet the standards under Rule 15 that good cause to miss the hearing. He had access to mail, a phone, and internet. And contacted PwC to explain about these phone or mail problems that he felt were interfering with his ability to participate in the process. The testimony did not show that his non-appearance at the first hearing was beyond his control. Accordingly, we should affirm the AC decision and not have good cause to miss the first hearing and not entitled to additional weight.
Affirm the WCAT. Claimant did not establish good cause for WCATA 1. Wage claim dismissed, no wages owed.
Short form dissent.
Yes, sir, Commissioner Alvarez. And that was the only wage claim case pulled for additional discussion on docket 25. You should have received the short form dissent list for docket 25.
I move to accept staff recommendations on the remaining wage claim cases on docket 25.
I second the motion except for those cases on which I'm dissenting, as reflected on the wage claim short form dissent list for docket 25.
Motion passes with the exceptions noted.
Thank you.
Thank you. Let's move to agenda item 7, consideration of unemployment insurance cases on docket 25. Please proceed when you are ready.
Case number 2606763, Commissioner Demerson.
These decisions should be affirmed. Claimant received $120,000 in severance pay from the employer and didn't recover 50 weeks of pay. The claimant testified that he did not negotiate this payment, nor was it based on a filed claim or a cause of action, or an alleged violation of the Civil Rights Act 1991. Rather, the payment was based on an agreement between the employer and the claimant's prior employer during the sale of the business. Such an agreement do not constitute a non-qualifying circumstance under section 207.049B2 of the Act, since that section implies that the contract must be negotiated either by the employee or by someone assigned specifically to represent the employer, such as the union representative charged to negotiate the collective bargaining agreement. Here, there is no indication that such an individual is assigned to represent the claimant to negotiate on this act. Instead, it appears that the agreement was signed without any knowledge or involvement by the claimant. As such, the pay the claimant received constitutes disqualifying severance pay, and trying to keep the severance qualification from June 28, 2020 to June 19.
The decision is not correct. The claimant's severance was based on a written contract negotiated with the employer before the claimant's separation. As a result, it was not disqualifying under the Act. Reverse the AT, severance pay eligible.
Reverse the 18, no severance disqualification.
Yes, sir, Commissioner Demerson.
Case number 2654848, Commissioner Alvarez.
The AT decision in this case should be reversed. While the claimant initial claim did not fall in the period in which claims were automatically backdated, she succeeded in filing the IC shortly after that period ended. She also provided credible testimony that she attempted to reach the commission repeatedly since March 2020 without success. Records reflect that the commission was overwhelmed with individuals attempting to file a claim or obtain information during that time. The claimant established adequate cause for her claim to be backdated. It should be backdated to March 22nd, 2020.
This decision to be affirmed. The claimant commission's fact-finding statement established that she made a few attempts to file a claim back in March and April. Not renew her following attempts until March. Consequently, her testimony that she was guilty in attempting to file her initial claim is not credible. Claimant should be held to her initial statement, provided for backdating request is denied. Moreover, there is no evidence that the claimant misled by PwC regarding the automatic backdating of her claim. As such, she should affirm the AT decision, deny the claimant's request for backdating.
Affirm the AT backdating denied.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2703533, Commissioner Demerson.
This decision to be affirmed. I did not contest the good cause finding. As to the job separation, the claimant stopped working to attend and support the family house. When the claimant left, he did not provide the employer with a return date. As such, the job separation in this case occurred when the claimant took an indefinite leave of absence from work for personal reasons. Since none of the exceptions to disqualification apply to the facts of this case, the claimant quit without work connected to the cause. We should affirm the AT decision. Claimant has good cause for his non-appearance, voluntary leaving, no charge back after employer response.
The claimant had good cause for his non-appearance. He was also using a borrowed phone to attempt to attend the first appeal tribunal hearing and was misinformed that the callback number for the phone. In accordance with case number 504981, the claimant had good cause as he had made good faith effort to participate. Regarding the separation, both parties testified the employer's policy was to contact the employer for reassignment when the assignment concluded. The claimant left his assignment with permission to attend to a personal matter. The assignment was not over and the claimant intended to return. The employer clearly did not consider the claimant to have quit by failing to contact the employer, as they later told him to report back when he was available. The claimant was unable to make it back to Texas due to shelter-in-place orders. The employer has not provided evidence of misconduct. Since the disaster impacted this separation, it would be appropriate to protect the employer's account. Modify the AT good cause, no misconduct, no chargeback, no overpayment.
Modify the AT, claim established good cause for AT1, voluntary leaving, no chargeback, sever adequate response.
Ms. Miller,
Yes, sir.
short form dissent.
Yes, sir. And I'm just looking at the clarifying the adequate response vote for Commissioner Demerson. It's a minor technicality, but you've severed it and Commissioner Demerson did not.
We're going to agree with the chairman on that.
Thank you, sir. And I have your short form dissent, Commissioner Alvarez.
Yes, ma'am.
Case number 2721663, Commissioner Demerson.
The appeal tribunal decision should be reversed. Regarding timeliness, the employer presented sufficient testimony to overcome the presumption of receipt, and as a result, its appeal should be deemed timely. As to the job separation, the employer stated that the claimant left for personal reasons, which is enough information to reasonably conclude that the claimant initiated the job separation. Since there is no indication that the claimant's separation was due to good cause connected with the work, the employer's account should not be billed. We should therefore reverse the AT decision, timely employer appeal, reimbursing employer not billed.
The employer has alleged non-receipt and TWC misinformation. As such, I will contest a finding that the employer submitted a timely appeal. Regarding the merits, the employer has failed to provide sufficient information to support a finding that the claimant quit for personal reasons. Modify the AT timely employer appeal, bill reimburse an employer.
Reverse the AT, timely employer appeal, reimbursing employer not billed.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2722379, Commissioner Demerson.
The appeal tribunal decision should be reversed. Regarding timeliness, the employer presented sufficient testimony to overcome the presumption of receipt, and as a result, its appeal should be deemed timely. As to the job separation, while the employer stated that the claimant's assignment came to an end, it also stated that the claimant had the option to renew the contract, but chose not to do so. Moreover, the employer also stated that it still had work for the claimant if she chose to renew her contract. As such, the claimant was in full control of whether she would resume working with the employer. Since there was work available for the claimant that she chose not to pursue, the employer's account should not be billed. We should therefore reverse the AT decision, timely employer appeal, reimbursing employer not billed.
The employer has alleged non-receipt and TWC misinformation. As such, I will not contest a finding that the employer submitted a timely appeal. Regarding the merits, the claimant was temporary employee who completed the assignment for which she was hired. As such, the claimant became separated for reasons other than misconduct. Modify the AT, timely employer appeal, bill reimbursing employer.
Reverse the AT, timely employer appeal, reimbursing employer not billed.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2755286, Commissioner Demerson.
The AT decision should be modified. The claimant resigned due to medical reasons. As such, I do not dispute her qualification for benefits under section 207.045D of the Act. However, that section of law allows for exceptions to disqualification. It does not establish that a claimant has good work-connected cause for quitting. Ultimately, the claimant's quitting due to medical reasons was personal and without work-connected good cause. As such, the employer in this case should not be billed. We should therefore modify the AT decision. No voluntary leaving, reimbursing employer not billed.
The decision should be affirmed. The claimant has osteoarthritis in her leg, and she was unable to climb stairs onto the buses, which was an essential part of her job duties. The claimant provided medical evidence that she has a permanent restriction on climbing. The employer testified that there was no light duty work available for the claimant. Because the claimant was unable to perform an essential part of her job duties due to illness, she had good cause connected with the work for quitting. Affirm the AT, no voluntary leaving, bill reimbursing employer. If my fellow commissioners do not agree, then this case should be reheard to admit the medical documentation that the claimant provided regarding her illness and restrictions.
Affirm the AT, no voluntary leaving, bill reimbursing employer.
Short form.
Yes, sir, Commissioner Demerson.
Case number 2757598, Commissioner Demerson.
The appeal tribunal decision should be modified. The claimant received severance pay in a lump sum that was equal to 12 weeks of salary. The claimant signed the separation and release of claims agreement on a date that was after her job separation. The severance pay does not meet any of the non-disqualifying circumstances found in section 207.049B of the Act. However, the dates of disqualification should be modified, since the claimant stated she received the lump sum payment on May 29, 2020. We should therefore modify the AT decision, severance disqualification from May 24th, 2020 through August 15th, 2020.
The decision should be reversed. The claimant was paid a lump sum based on a 2007 agreement that was revised in 2019. As the agreement was a written contract negotiated between the parties before the claimant's separation in 2020. The payment is not disqualifying under section 207.049 of the Act. Therefore, the decision should be reversed. Reverse the AT, no severance disqualification.
Reverse the AT, no severance disqualification.
Short form dissent.
Yes, sir, Commissioner Demerson.
Case number 2763170, Commissioner Alvarez.
The decision should be modified. No voluntary leaving, no chargeback, MBI, and void adequate response. The claimant was separated when her pregnancy prevented her from being able to perform her job. The claimant provided medical documentation and was approved by FMLA. The employer's appeal makes it clear that they agree with the pay and protect ruling and were only appealing because the AT decision incorrectly ruled on the adequate response issue. As the claimant was separated due to her medical condition, she should be qualified for benefit and the employer's account protected from charge. Additionally, since the claimant is qualified for benefits, we should void the adequate response ruling. Modify the AT, no voluntary leaving, no chargeback, MVI, and void adequate response ruling.
I would agree with Commissioner Alvarez.
Can you read back that to me? please?
It's pay and protect, void the adequate response. So claimant qualified and the employer protected under MVI.
Yeah, no voluntary leaving, no chargeback MVI.
Yes, sir.
Is that right? Void adequate response. Also, can we add to that a memo to investigate claimant's ability to work beginning July 5th, 2020?
I'm sorry with the date.
Memo, July 5th, 2020.
I have that memo and we have a unanimous decision.
Case number 2783733, Commissioner Alvarez.
The decision should be reversed. No misconduct, chargeback. The claimant was hired on a probationary period. He was discharged when he failed to meet protection quota for the second time. However, there is no allegation that the claimant was not working to the best of his ability. His failure was caused by the employer moving him to a different departments and because sometimes there was not enough work. As the claimant was working to the best of his abilities and met the employer's production requirements for 15 out of 17 weeks, the employer has not shown misconduct. Reverse the AT, no misconduct, chargeback.
The appeal tribunal decision should be affirmed. The claimant was discharged due to his poor work performance. The claimant was able to meet expectations for the majority of the time he was employed. However, he failed to meet his productivity rate for 2 different weeks and was fired. The claimant was also made aware by a supervisor that his productivity rate needed to increase. In addition, the employer also stated that the claimant could request downtime when he did not have enough work to protect his productivity rate. As such, the claimant's poor job performance was the equivalent of work-connected misconduct, and we should affirm the AT decision, misconduct, no chargeback.
Reverse 18, no misconduct, chargeback.
Short form.
Yes, sir, Commissioner Damerson.
Case number 2798851, Commissioner Alvarez.
The AT decision in this case is not supportable. The claimant was discharged because he transferred some documents to a hard drive. The employer concluded that he was stealing documents from the company in order to compete with the employer. However, the claimant is a part owner of the company and therefore has ownership interest in the company's documents. The claimant provided credible testimony that he transferred the documents to assist in finding other work when the employer's Houston's office closed. The employer in this case has offered no information about this work separation and did not participate in the AT hearing. There has been no rule or policy provided that the claimant supposedly violated, and the exact nature of the documents has not been established by the employer. The evidence is insufficient to support a ruling that the claimant was discharged for misconduct connected with the work. Reverse the AT, no misconduct.
We should affirm the appeal tribunal decision. The claimant admitted that he had transferred company documents to his own personal hard drive for personal use. In fact-finding statements, he also admitted to transferring the company information for use in his next business moves. By transferring company documents to his own equipment for his personal use and without authorization, the claimant mismanaged his position of employment. We should affirm the AT decision, misconduct.
Affirm the AT, misconduct.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2799970, Commissioner Alvarez.
The AT decision is not supportable. The claimant quit the job because of her husband's illness. In her appeal to the commission, the claimant has stated that her husband is in hospice care, which indicates that her husband is terminally ill. Consequently, the claimant's separation should not be disqualified under Section 207.046(a)(3) of the Act. Alternatively, if the commissioners do not agree to qualify the claimant under Section 207.046 of the Act, the case should be reheard. The claimant has never provided medical documentation to establish that her husband is terminally ill, but she has had no reason to know that such documentation is relevant. The notice of telephone hearing provided no information about voluntary leaving due to terminally ill spouse, and the appeal tribunal did not inquire about or develop on the record on this particular issue. In order to protect the claimant due process rights, if the claimant is not qualified for benefits, the case should be reheard to determine whether the claimant's husband suffers from a terminal illness.
We should affirm the appeal tribunal decision. The claimant quit for a very compelling personal reason, but not for good causes connected with the work. Thus, we should affirm the AT decision, voluntary leaving. However, in the alternative, because the claimant has provided information which suggests that her spouse may be terminally ill, I would agree to rehear the case to allow the claimant an opportunity to provide the documentation required by section 207.046A3 of the Act.
Reverse the AT, no voluntary leaving under section 207.046A3.
Commissioner Alvarez, either one of your votes, your primary vote or your alternative vote, has possibly achieved a majority. Did you want to go with your primary vote or your alternative vote?
Primary, reverse, no voluntary leave.
Thank you, sir.
From a short form dissent.
Yes, sir,
In
Commissioner
in
Demerson.
addition, send a memo to investigate whether the claimant is available for work.
Availability memo, sir.
Thank you.
Case number 2799981, Commissioner Alvarez.
The decision should be reversed. The employer discharged the claimant, and the employer bears the burden to demonstrate that the claimant committed misconduct connected with the work. The employer has provided only vague hearsay regarding cleanliness of the store. The employer has not provided any policy violated nor any record of warnings. The employer did not provide any record of failed inspections. The claimant, who has 9 years of experience with the employer, provided sworn testimony that her store was clean. The evidence fails to establish misconduct connected with the work. Reverse the AT, no misconduct, chargeback, no overpayment.
We should affirm the appeal tribunal decision. Regarding the job separation, the employer gave the claimant feedback in the form of failed inspection reports about the employer's expectations for the cleanliness of the store. Despite this, the claimant never broached the subject with her manager so that she could improve her performance, even though she had multiple opportunities to discuss the issues with him face to face. Thus, because the claimant's performance did not improve after multiple warnings, the claimant mismanaged her position of employment. Because the disqualification is appropriate, the resulting overpayment is also appropriate. We should affirm the AT decision, misconduct, no chargeback, overpayment of $458.
Reverse the AT, no misconduct, chargeback, no overpayment.
Short form.
Yes, sir, Commissioner Demerson.
Case number 2801463, Commissioner Alvarez.
The claimant was on an approved medical leave of absence. The employer alleged that the claimant failed to keep in contact with the employer and failed to submit medical documentation to extend his leave until 1 hour after he was discharged. The claimant was not questioned about whether he was aware that he needed to contact the employer or about the timing of his submission of medical documentation. As such, a rehear would be appropriate to better develop the record. In the alternative, I would also support modifying the AT decision to no misconduct, no chargeback, MBI, because the claimant's separation was caused by his documented medical issues.
We should affirm the appeal tribunal decision. The facts surrounding the final incident are not in dispute. The claimant admitted in his fact-finding statements that he did not keep the employer informed of his absences. Under the employer's policy, 2 days of no call, no show resulted in a job separation. As property manager, the claimant should have been aware of the policy. By failing to notify the employer of his 2 consecutive absences, the claimant mismanaged his position of employment. Accordingly, we should affirm the AT decision, misconduct, no chargeback.
Affirm the AT, misconduct, no chargeback.
Short form of dissent.
Yes, sir, Commissioner Alvarez.
Case number 2804137, Commissioner Demerson.
The claimant's disqualification is fully supportable. In November of 2019, the employer instructed the claimant to ensure that terminated employees were removed from the employer's insurance. Months later, the employer discovered that the claimant had not successfully carried out this task. If the claimant had trouble keeping up with the work, the employer could have helped. Yet, when the employer offered the claimant assistance, she turned it down. In addition, although the claimant alleged she had prepared a spreadsheet with a list of the employees that needed to be removed from the system, she never forwarded that list to the employer. Thus, because the claimant failed to carry out her assigned duties as instructed, and this failure resulted in a loss of thousands of dollars to the employer, the claimant mismanaged her position of employment. We should modify the AT decision, misconduct, no chargeback, add adequate employer response ruling.
The decision should be reversed. The claimant provided sworn testimony that she did not have the authority to remove the terminated employees from insurance. Only the benefit manager could do so, and the claimant had provided the benefits manager a list of employees who needed to be removed. The claimant's manager testified that she discovered the issue with terminated employees in November of 2019, but there is no evidence that the claimant was ever warned that the employer thought she was failing to carry out her duties at that time. The evidence is insufficient to provide misconduct connected with the work. Reverse AT, no misconduct, chargeback.
Modify the AT, misconduct, no chargeback, adequate employer response.
Short form dissent.
Yes, sir, Commissioner Alvarez.
Case number 2811032, Commissioner Demerson,
That we should modify the appeal tribunal decision. The claimant admitted that he was discharged after a physical altercation with a staff member. The claimant acknowledged that in addition to hitting the coworker's computer keyboard to get her attention, he grabbed the coworker by the shoulders twice as she tried to walk away from him. The claimant's behavior was inappropriate, unprofessional, and completely unacceptable. The length of time between the final incident and the date of the claimant's discharge does not render the final incident too remote in time. The employer's decision to wait until the claimant had returned from legally protected FMLA leave before proceeding to termination protected the claimant's rights. This was not a discharge at the employer's convenience. Accordingly, because the claimant mismanaged his position of employment by escalating the disagreement onto the physical plane, his disqualification is appropriate. We should modify the AT decision, misconduct, no chargeback, sever the adequate response ruling.
The AT decision should be reversed. The claimant had an altercation with a coworker in December of 2020, which the employee cited as the reason for his dismissal. However, the employer waited 6 months until after the incident to actually discharge the claimant. The final incident was too remote in time from the discharge to constitute misconduct connected with the work. Reverse AT, no misconduct, chargeback, void, adequate response ruling.
Modify the AT, misconduct, no chargeback, sever adequate response.
Short form dissent.
Yes, sir, Commissioner Alvarez. And that was the last UI case pulled for additional discussion on docket 25. You should have received the UI short form dissent list for docket 25.
I move we accept staff recommendations and remaining UI cases on docket 25.
Chairman, I second the motion except for those cases on which I'm dissenting as reflected on the UI short form dissent list for docket 25.
I concur with the chairman's motion, except for the cases on which I'm dissenting is reflected in the UI short form dissent list for docket 25.
Motion passes with the exceptions now.
Thank you, sir.
Thank you. Let's take a quick break. We'll get set up for the rest of this meeting. This changes everything. I'm gonna have to get my other script done. All right, let's start with agenda item 8. This is FY 2022-24 final Child Care and Development Fund State Plan.
Shit.
Check.
My mic was off, so I know it wasn't me. Allison, are you there? Chairman, I suggest we move to the next item and come back once we resolve the technical difficulties.
Can you hear me? Can you hear me?
Yes, we can.
Okay. I apologize. I don't think I had the right link this morning, but I'm here now. So good morning, Chairman, Commissioners, and Mr. Townsend. For the record, Allison Wilson with the Child Care and Early Learning Division. Today, for your consideration, we are bringing forward the final CCDF state plan for federal fiscal years 22 through 24. The CCDF state plan is the primary mechanism that the Administration for Children and Families uses to determine a state's compliance with the requirements of the Child Care Development Block Grant Act. The plan is also a vehicle to publicly share state CCDF policies and quality improvement investments. During the development of the final plan, we sought and received input from the public and numerous stakeholders, including child care providers, advocacy organizations, workforce development boards, and state partners. The final plan addresses much of this input as well as changes that arose from the legislation passed during the recent 87th legislative session. Along with the final state plan, we also bring forward the Child Care Statewide Emergency Preparedness and Disaster Plan, which is a CCDF state plan component. The disaster plan has been updated to incorporate lessons learned since the last publication in 2018. The Texas Department of Emergency Management, HHSC's Child Care Regulation Division, the Texas Early Learning Council, and local boards provided input to inform these revisions. We seek your direction on submitting the final state plan to the Administration for Children and Families Office of Child Care on or before June 30th. We also request that staff have authority to make technical changes as needed prior to submission. And I'm happy to answer any questions you have.
Comments or questions?
Chairman, I have a comment regarding this particular agenda item. Before we take any action on this item, I wanted to discuss a recent exchange I had with the Houston delegation and specifically with Dr. Quianta Moore, a Hovington Fellow in Child Health Policy with Rice University. She explained the profound impact the language has on our child care program and what it has along with its parents. The word subsidies can have a negative connotation. If we change that term to scholarships, we will find that we are not only change expectations for the child, but also find that the parent becomes invested in the program. For example, my child received a scholarship rather than my child received subsidized care. By phrasing the financial assistance we provide as child care scholarships, we would help reinforce the idea that the parents are receiving something of value, something to be proud of, and it helps the parents to be invested in the child care they are receiving. It also highlights the value of the education we are providing to our children. As our program continues to reinforce the importance of quality child care, we have an opportunity to drive home the point that we are investing in these parents and their children. I would ask staff to look at changing the language around the child care program to move away from subsidized to child care scholarships. In our interactions with parents and our messaging with providers, parents, partners, children, and the public, I look forward to having staff bring their ideas on how to implement this change.
Thank you, Commissioner Alvarez. We are certainly happy to look into that for you.
No other comments here? I think it's a good idea to have staff to look into that. I had the pleasure of hearing her presentation as well, and I think there's something to it. And so it'd be good to have staff to go out, look into it, look at the advantages of marketing the program that way, and see if there's any inherent benefits of it.
Are you asking for that to be changed in this report or just to bring it forward for action on a later date?
Bring it back later on.
Later, a later date?
That's correct, sir.
All right. All right, so any other comments on today's?
comments.
So staff will bring back at a later date some recommendations for a policy decision with regard to what we call the subsidy. And today, I think we need to take action on this report and move it along.
Okay. Chairman, are you ready for the motion? I move that we approve the CCDF state plan and the emergency preparedness and disaster response plan and allow staff to make any technical corrections as needed.
Second.
It's been moved second, and we're unanimous. Is that it on 8? Yes.
Chairman, I believe that's it for
All right.
that judging item.
I don't think we have anything on 9. Do we have anything on 10?
We do not have
We do
anything
not
for
have
10.
anything on 10. Board nominations, agenda item 11.
Hello, good morning, Chairman, Commissioners, and Mr. Nelson. For the record, Shonta Williams with the Workforce Development Division. And before you today for consideration, we have Workforce Board nominations from 3 areas. Staff recommends approval for Workforce Solutions Gulf Coast, Middle Rio Grande, and Texoma. That concludes my request, and I'm here to answer any questions you have.
Comments or questions?
None here, Chairman.
None.
Do we have a motion?
Chairman, I move that we to approve the board nominees for Gulf Coast, Middle Rio Grande, and Texoma.
Second.
It's been moved second, and we're unanimous.
Thank you.
Thank you. Nothing on 12. How about 13? No.
Have nothing on 13,
How about 14?
not from me.
This is your chance to have an executive director's report. They're letting you sit there.
I may not be able to come back if I go too far.
That's wisdom in action right there is
It
what we
is.
just saw. Is there any other order of business to come before the commission?
None here, Chairman.
None here.
Is there a motion to adjourn?
Chairman, I move that we adjourn.
Second.
It's been moved and seconded to adjourn. We're adjourned.